Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and today's contract tip has to do with the survival of closing. What provisions in a real estate contract survive closing and what provisions do not survive closing, and why on earth is all of that important? Well, if you've ever seen me in a class, you have heard me say nothing is an issue until it's an issue. Well, this clause, this concept of what survives closing or not, has something to do with if it becomes an issue, how is that handled legally? So first of all, let me tell you what the survival of a closing, what that means in a contract. And what it means is in order to ensure that certain promises continue or survive and don't end or merge together on a closing, express provisions to that effect are inserted in the agreement of the purchase and sale agreement. So let's look at both the GAR, the Georgia Association of REALTORS contract, and the RE forms, and let's see what they say about the survival of closing and then what that all means. So in the GAR purchase and sale agreement, which is F201, in paragraph C4L, it says survival of agreement. The following shall survive the closing of this agreement. Number one, the obligation of a party to pay a real estate commission. Yay! Number two, any warranty of title. Number three, all representations of the seller regarding the property. And four, the section on condemnation. And five, any obligations which the parties herein agree shall survive the closing or may be performed or fulfilled after the closing. Now that last provision is where it affects you as an agent and how you can tie in a situation to survive closing. In the RE forms, this is all spelled out in the standard terms, which is RE1, paragraph 12.7. Unless expressly agreed otherwise in the contract, or unless provided otherwise in any other document executed by the seller and buyer at or prior to closing, the provisions of the contract shall survive closing. That's a huge difference. In the RE forms contract, the entire contract survives closing. In the GAR purchase and sale agreement, that contract, just those 5 items survive closing. So, in the GAR contract, I'm just going to focus on that for a second. Did you hear the word repairs? No. Did you hear the words home warranty? No. So, if a buyer and a seller negotiate, for example, for repairs or for the seller to purchase a home warranty for the buyer, if you do not specifically indicate that that provision or that agreement shall survive closing, the obligations end at the closing table. So I want everybody to write this down. Here's a magic phrase. You know what? I'm going to give you the magic phrase at the end of the video. So stay tuned and watch the video. So here's a real life example. Let's say that, well, let's not say, this was an example. Clients purchased a home and they closed on the home, and then they lived in the home, and later on, fairly soon after the closing, a few months after the closing, they discovered that there was water intrusion in the basement. So going back, the agent went back and looked at the property disclosure form, and on the seller's disclosure form, the seller did note that there had been water intrusion in the basement in the past. So the seller did disclose that defect with the property. And they also, in the seller's disclosure form, that was part of the purchase and sale agreement, indicated that they had corrected it, and they described how they had made that correction. The client, the buyer, after closing a few months later, discovered water intrusion in the basement, and they had somebody come out and look at it, and the service provider they had come out and look at it said that that correction that the seller indicated would not have corrected the situation. So the issue is, what do they do now? Do the buyers have recourse against the sellers legally? Again, it's not an issue, and now it's an issue. Well, a couple of things. Generally speaking, one is the status or the state of the property now that the buyers have lived in there is not necessarily indicative of the state of the property at closing. And this season, we're in the winter of 2020, we have had a lot of rain. So that's one factor to consider. But getting back to the contract, the contract in and of itself, both GAR and RE forms give a caveat or give an admonition to the buyer to make sure that they check out the property before they close on it. Now, there is the due diligence period, and in the GAR purchase and sale agreement, the due diligence period is spelled out in paragraph B8D, and it says property sold as is, unless this contract is subject to a due diligence period. Unless the property is being sold subject to a due diligence period. Well, I'm not going to read that paragraph to you, but basically a buyer has the opportunity to do whatever they need to do to check out the property and determine if they're going to terminate or go through with the property. And that does include negotiating some items with the seller. In the RE forms paragraph, that is called the buyer's right to terminate, and that is in paragraph 6.1, again, of the RE1, the standard terms. Now, also in both the GAR purchase and sale agreement and in the RE forms purchase and sale agreement, there is further admonition to a buyer to make themselves satisfied with the property. In GAR, it's in the purchase and sale agreement in paragraph B10C, and it states buyer and seller should seek independent expert advice regarding any matter of concern to them relative to the property in this agreement. And in the RE forms contract, again, it's in the standard terms, paragraph 7.1, under condition of property duty to inspect, seller and buyer have been advised and expressly acknowledge their obligation to conduct a thorough investigation or to obtain independent professional advice with respect to any concerns they may have regarding the contract or the condition of the property, surrounding neighborhoods, so forth and so on. So let's get back to this concept of surviving closing. So also, Georgia is what's called a caveat emptor state, or buyer beware. For anything a buyer is going to purchase, the burden or the onus is on them to make sure they are satisfied with the goods or services they are purchasing before they exchange money and with real property, before they close on the contract. The burden is on the buyer to make sure they are satisfied. And in both the GAR and the RE forms contract, that time frame for them to do that is handled in that due diligence time frame. So back to the issue, the specific example where a buyer closed on a house a few months ago, now has discovered water intrusion, so forth and so on. The buyer cannot hold a seller responsible for their lack of due diligence. So especially since it was disclosed in the seller's disclosure form, the buyer maybe should have had that checked out further. Anyway, back to, there was another case, and an agent had a case. It did go to court. It was a very similar situation. And the judge's ruling on a similar situation stated that since that provision did not survive closing, and that was not one, it was written on a GAR purchase and sale agreement, it was a little bit different. There was a repair issue that the seller had done. The seller had done it. It failed later after the buyer's purchase, and that provision did not survive closing because they did not indicate that that repair that the seller had performed does survive closing. So it was that agreement, that amendment to the purchase and sale agreement, what had no force or effect. So the case was dismissed. So, you ready for the magic phrase? Okay, get out a pen and a piece of paper and write this down. Here are the magic words. This provision shall survive closing. This provision shall survive closing. So whenever a buyer and a seller are negotiating for items that on the GAR purchase and sale agreement that aren't one of those 5 itemized items, you probably want to consider using that phrase. For example, if the buyer and seller negotiate on an amendment to address concerns for the seller to handle some some repairs, you probably want to add this provision shall survive closing. Then that gives a legal basis for perhaps legal remedy if that seller did not perform that repair after closing. Another example is if a buyer and a seller negotiate for a seller, let's say the seller agrees to buy a 1-year home warranty for the buyer. Well, you get to the closing table, it's not on the HUD, you don't think about it. Later on, a week later, the buyer's agent calls the listing agent and says, guess what? We forgot to put the home warranty on the closing statement, so I need your seller to go ahead and call and pay for a 1-year home warranty for the buyer. And the listing agent says, oh no, so sad, too bad. That provision didn't survive closing. The seller is no longer obligated to purchase a home warranty for the buyer. And the buyer's agent says, oh no, 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 so sad, too bad. I watched Dana's video and I learned the magic phrase. And you will remember when we negotiated for that, we added this provision shall survive closing. So the seller is obligated to purchase that home warranty for the buyer even after closing. So those are just a couple of examples of what survives closing, how it's important, and how that magic phrase will help you. And the reason that magic phrase helps you in the Georgia Association of Realtors contracts is, again, that 5th provision that's itemized of what survives closing specifically states any obligations which the parties herein agree shall survive closing. So if you use that magic phrase, this provision shall survive closing, and the buyer and seller sign it, then they are in agreement that that shall survive closing. Thank you guys so much for watching. Please like this video if you found it informative, and subscribe to this YouTube channel check out the playlist for lots of videos designed to help you as a real estate agent here in Georgia. And thank you guys so much for watching. Dana Sparks, broker of Maximum 1 Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.